This is Trump on Earth. I'm Reed Frazier. Ruth Bader Ginsburg was a feminist icon in the U.S. as one of the first women in many of the roles and rooms she found herself in over her long life. Her death at the age of 87 and the subsequent race by the Trump administration to confirm her successor will remake American law for decades, perhaps putting decisions like Roe v. Wade in jeopardy. But it could also remake American environmental law. Today, we'll look ahead at what the loss of RBG will mean for the environment. But first, we take a look back. That's coming up in a minute. Stay with us.
Hi, I'm Nate Cubis.
And I'm Reggie Cubis.
We're the sons of Trump on Earth producer Andy Cubis.
She works behind the scenes.
We think you should support this podcast on how do you say this word? Patreon. Because the environment matters for us kids.
Go to patreon.com/TrumpOnEarth to learn more.
You can pledge as little as $1 a month.
We can even afford that with our measly allowance, right, Nate?
Right. Thank you.
Ruth Bader Ginsburg is being remembered, rightly so, for being a strong advocate on the bench for women's rights. But she was also an advocate for the environment as a Supreme Court justice. To talk about that legacy, I'm joined by Pamela King and Jeremy Jacobs. Pamela is legal editor at E&E News, and Jeremy is a reporter for E&E News. Pamela and Jeremy, thanks so much for taking the time to talk with me.
Thanks for having us.
Happy to be here.
So, Pamela, we're going to start with you. Tell us about Ruth Bader Ginsburg's environmental legacy on the court. What sticks out to you?
Well, of course, Justice Ginsburg is very well known for her work, her advocacy for women's rights, but something that we explored over the weekend after her passing on Friday night was her environmental legacy. And the case that we highlighted was the 2000 case, Friends of the Earth, which was a 7-2 ruling.
We'll hear argument next to number 98-822. Friends of the Earth versus Laidlaw Environmental Services.
Ginsburg wrote the majority opinion in that case, which dealt with pollution discharges into a South Carolina river. And Ginsburg wrote for the majority that the case wasn't moot simply because the company in question had stopped polluting the waterway.
One of the questions that I have is, assuming I would agree with you that this case is not moot, mustn't this court stop there and say whatever the district court found, the Court of Appeals didn't review it, so we would say case not moot, Court of Appeals, stop assuming standing, decide all these questions that you didn't decide. What right would we have if we agree that the case isn't moot to decide anything but that?
But the key takeaway here was Ginsburg's broad view of environmentalists standing to sue, which is a really important issue, and it can kill legal challenges in the early stages if a judge says that a party doesn't have the power to bring a lawsuit in the first place. Justice Ginsburg found that Friends of the Earth, the environmental group in this case, had raised reasonable concerns about the pollution discharges and their impact on recreational, aesthetic, and economic interests. Justice Scalia, actually, a conservative on the court and a close friend of Ginsburg's, wrote the dissent in that case. He was not a supporter of environmental group standing and wrote that Ginsburg had created a watered-down requirement. And we also highlighted several other cases. Jeremy, do you want to talk a bit about Homer City?
Yeah, so one notable case was a case in 2014 where she actually wrote an opinion in a case challenging an EPA program for air pollution that drifts across state lines, which is an extremely complicated thing to regulate. And she overturned the lower court decision in that case in the 6-2 ruling. And the decision from the court below, the U.S. Court of Appeals for the District of Columbia Circuit, was actually written by Justice Kavanaugh when he was on that court. And it's the only time that one of Kavanaugh's opinions from that circuit court had been overturned.
Justice Ginsburg has our opinion this morning in Case 12-1182, EPA versus EME Homer City Generation, and the consolidated case.
And Ginsburg did it in some pretty colorful and brazen language that showed that she was receptive to the environmental arguments for why regulating pollution in such a way was important.
All agree this is no easy task, for non-attainment in downward states result from the collective and interwoven contributions of multiple upward states. As expressed in the holy book, the wind bloweth where it listeth, thou hearest the sound thereof, but cannot tell whence it cometh and whither it goeth.
And correct me if I'm wrong, but this was a case where Ginsburg and the rest of the court decided that, the EPA could do more to regulate air pollution that goes across state lines, like from Ohio to Pennsylvania or Pennsylvania to New York or something like that.
Yes, that's right. And it's particularly relevant in that part of the world you're in, where you have upwind and downwind states, and sometimes you have states that are both upwind and downwind. So EPA has been trying to develop a regime to do that for decades. Multiple administrations have tried, and it always winds up in court. And the Ginsburg opinion in that case was really a landmark decision that gave EPA leeway to try to address that problem.
So you guys talked to a number of legal scholars and, attorneys that represent various parties that are often in these cases. Jeremy, we'll start with you this time. What were some of the things that stood out about what people told you about Ruth Bader Ginsburg?
Well, I think there's a couple kind of themes that came up when people looked at her legacy from through an environmental lens. First, just to say it, is reverence, right? Just across the board, no matter where you are on the political spectrum, there's a deep respect and reverence for everything that she did in her life. But in the environmental realm, there's kind of a couple of things that kind of shone through. One is that, like I said earlier, she was receptive to the environmental impacts and public health impacts that came up through litigation. So you had some scholars saying that with her leaving the court, one of her legacies is that's not necessarily there anymore. And there isn't really a voice on the court that looks at these cases from less of a regulatory or technocratic viewpoint than an environmental viewpoint. And that's something that's now kind of a big hole on the court. Obviously, we'll see who her successor is, but I would say there's definitely concern among environmental groups and administrative law and legal scholars because of that.
Pamela, what about you? What stuck out when you talked to people about RBG's legacy?
Yeah, I would echo what Jeremy said about, reverence across the board. Justice Ginsburg was incredibly devoted to her job. Notably, she called in one day to arguments last term after they moved to phone arguments in light of the coronavirus pandemic. And she had called in one day from a hospital bed where she was recovering from an infection. And yeah, I would note that she was a reliable vote for environmental interests in cases generally, and, really favored expansive readings of not just the Clean Air Act, but also the Clean Water Act. She was a key vote in many of those cases for, more oversight of waterways, streams, wetlands across the country.
Pamela Ginsburg also wrote an opinion in something called American Electric Power.
Does the federal common law of public nuisance authorize suits by states, cities, and private parties to abate carbon dioxide emissions on the theory that they contribute to global warming? That is the question this case presents.
Can you talk to me about that?
Sure, yeah. Justice Ginsburg led the unanimous opinion in that case. It said states and private entities couldn't use federal common law to sue companies for greenhouse gas emissions. But she emphasized the court's earlier ruling in Massachusetts versus EPA, in which she was in the majority, that said the government could offer relief to the climate problem. The case is interesting because cities and states are launching similar attempts right now to sue oil and gas companies over their contributions to climate change. And those cases are moving forward in state court, however. So they're not trying to use federal common law to make their complaints. And there's actually one petition pending before the Supreme Court this term that asks the court to find that Baltimore's climate case belongs in federal court instead of state court. This is the industry attorney's request. But so far, the courts have largely said that those cases belong in state venues. So we still don't know what the state courts are going to say about those cases, but for now, they are starting to play out.
Do you know how Justice Ginsburg informed herself about environmental issues? How did she keep up?
The only thing I can say is that, my recollection from my time sitting in on environmental cases at the court, back when we could go in person, was that Justice Ginsburg was often out in front of the questioning with really, sharp and insightful questions that showed that she had done a really close read of the briefs in the case.
But you are including at least wetlands that abut navigable water.
Yes, traditional navigable waters plus abutting wetlands inseparably bound up.
What about major tributaries?
Congress cannot regulate all tributaries, could regulate some tributaries, but would have to do so on a case-by-case basis. The regulation of all tributaries raises significant constitutional questions, and contrary to the regulation of wetlands that are inseparably bound up. And there's no clear indication that Congress intended to regulate any tributaries, let alone the entire tributary system.
Is your position no tributaries or some tributaries?
One person that watches the court really closely mentioned to us that she often asks the first questions in environmental cases, and she often asks questions that shape the way the case is decided. And that kind of shows her influence, I think.
Would the statute do anything more or less, in your view, if the word navigable were not there and they were just the words waters of the United States? In other words, does navigable have any function whatever? Not has it been defined away?
Pamela, it sounds like you got a chance to see her in action. What was that like?
There's always a buzz in the room when she started to ask questions. And like we said, it was often early on in the proceedings. People are always really excited to hear her speak, in the reporter's box. People are often there to see her.
Jeremy, did you ever sit in on any of her arguments? What was that like?
Well, she's so tiny. A lot of these guys are not huge, but they're large. And she's so tiny. But as soon as she starts speaking, the respect is clear, and her authority is pretty amazing.
Oh, one other thing that I would mention is that, a huge case for us at E&E last term was the Atlantic Coast natural gas pipeline case. And one of the Supreme Court artists in that case drew this really amazing photo of the justices hiking the Appalachian Trail, which was quite comical to imagine them doing that in their Supreme Court get-ups, which is what the illustration depicted. That was a case about whether the Atlantic Coast natural gas pipeline could cross beneath the Appalachian Trail. And it's one that we had tracked for quite a while at E&E. And actually that one was pretty interesting with respect to how Ginsburg came down in the case. Again, she didn't write the opinion here, but she did join a 7-2 majority that said the pipeline could cross beneath the trail. And that was, a rare vote for her in favor of industry interests. But overall, the impact of that ruling was pretty limited, and the project has since been canceled.
So did you guys find that her views or opinions on environmental cases evolved over time? What did you find out about that?
I didn't find that her views had evolved over the years. It seemed like she was pretty consistently siding with environmental interests, which some of my sources were saying to me over the weekend was very consistent with her thinking that, the little guy should have a voice in court, and the that in this case, that it was the environmentalists.
I mean, one other thing, as far as the void or hole that she leaves on the court, is the court also decides, they decide what cases they're going to hear, and it takes 4 votes to take up a case and hear it. And now there aren't, likely if Trump is successful in choosing her successor, there won't be 4 court votes on the liberal side. So it just makes it that much harder for environmental interests to get their cases to the court, let alone succeed if they're taken up. So it'll have an impact in that respect as well.
So that would be yet another kind of major shift that the court is about to undergo.
Yeah, it is. I wrote yesterday about, what this term is going to bring. And of course, the question of whether, environmental cases would even be granted was a big one. And, so far on the calendar for next term, we've only got a couple environmental cases, a water fight between Texas and New Mexico that experts don't say would be decided along ideological lines. There's a FOIA case about Endangered Species Act records, FOIA request for Endangered Species Act records, and the government has asked to protect some draft documents that informed an EPA rulemaking. But that one's interesting because, environmental groups and industry interests are aligning in favor of increased government transparency. So it's not clear whether Ginsburg would have been a crucial vote on that. But in the terms to come, especially depending what happens with the election, challenges to President Trump's environmental rollbacks could eventually come to the high court. If Biden wins, we could see him attempt to walk back some of those rollbacks, and those could eventually reach the Supreme Court. And court watchers are just really looking to see here whether, President Trump is successful in putting a third justice on the court, because it does seem like anyone he picks probably would not be in favor of increased environmental regulations and might strike down a challenge to a Trump rollback, or could strike down, a stronger environmental policy introduced by a potential Biden administration. So there's a lot to watch here.
Jeremy, any thoughts on that?
We can speculate in all the scenarios, and it's why I'm developing an ulcer. I guess that's the one other thing I would add is that in the court system, what we were saying about what courts get taken up and how receptive they are to let's call them pro-environment arguments or rulings. It trickles all the way down, because if you're an appeals court judge, you don't want to issue a ruling that's going to get reversed by the Supreme Court. It's a badge of dishonor, so to speak, right? So that's going to be in the back of their mind when when Court of Appeals judges are considering cases, and it goes all the way down. It represents kind of a foundational shift, I think, in how environmental law will be interpreted and how it will play out in court going forward.
Yeah, not to mention that Trump has appointed now more than 200 judges to the lower court. So a shift has already happened.
Yeah, and we'll leave it at that. Pamela and Jeremy, thanks so much for joining us.
Thank you.
Thank you.
Pamela King is an editor at E&E News. Jeremy Jacobs is a reporter there. You're listening to Trump on Earth.
My life had balance. I went to class in the morning, but then at 4 o'clock when the babysitter left, we went to the park. We played silly games. Each part of my life was a respite from the other, but I think it was appreciation that there is more to life than law school that accounts for how I did.
As we record, it appears as though President Trump may have enough votes in the Senate to confirm a new Supreme Court justice of his choosing before Election Day. That means the court's balance would tip from a 5-4 advantage for conservatives to 6-3. What would this majority mean for the environment? To talk about this, I'm joined now by Ellen Gilmer. She's a senior legal reporter for Bloomberg Law. Ellen, welcome.
Thanks for having me.
So we already have a 5-4 conservative majority on the court. What are the big ways that a 6-3 majority would impact the environment?
Well, it could affect a lot of things, and I think the main way we would see an impact on environmental law is actually through administrative law cases. And what those are just cases that deal with regulations in general, whether they have to do with the environment or not. The more that this kind of regulatory law changes, the more impact it has on environmental issues. So if we see a court that is pretty skeptical of various agencies' power to do regulations, to do certain types of regulations, then we're going to see that have ripple effects on environmental rules.
So you said administrative law. So does this mean if somebody sues the EPA for not following through on a regulation or like the Clean Air Act or something like that? Is that what we're talking about?
Yeah, totally. So a great example would be if the EPA, under a future Democratic administration, crafted some new climate regulations under the Clean Air Act, Supreme Court, depending on who's on the bench, it's not like an absolute sure thing either way. All this stuff is very fact specific in each case. But a more conservative court would probably be more skeptical about the EPA's power to use the Clean Air Act to address climate issues. They might say, hey, we think the Clean Air Act is more about conventional air pollutants. This is a step too far beyond what Congress intended. So that's the kind of dynamic that we expect to see on a more conservative court. Again, we don't have a crystal ball, so we don't know exactly how these kind of cases would go, but that's something that environmental litigants would be worried about.
So one theme we've been tracking for the last 4 years or so is, Obama created several big environmental regulations, many of them crafted towards climate, where, the most famous case is probably the Clean Power Plan. Trump has rolled those back. Those cases are now kind of all in court. Are these cases that a future conservative majority, I don't know if we want to call it a supermajority, but it's a better than a one-vote majority, would have more of a likelihood of, going with the rollbacks?
Yeah, it's definitely possible. And something that we've seen on the court previously in the past couple of years is Chief Justice Roberts acting as a swing vote sometimes. And so that came up in a couple of really interesting cases involving the federal government's kind of rationale for its actions. There was one case, not environmental cases, but there were a couple cases that listeners might remember dealing with the census citizenship question last year. And then this year there was the DACA immigration case. In both of those cases, Chief Justice Roberts wrote the majority opinion and was really that kind of critical vote siding with the traditionally liberal bloc of the court in saying neither of these actions fly because the agencies involved didn't properly explain their actions. They didn't properly, give a reasoned explanation for what they were doing. And that's exactly the kind of standard that's going to come up in future deregulatory cases. If a case about water jurisdiction reaches the Supreme Court, this is something the court's going to look at. If a case about power plant regulations comes up, methane regulations, all of that, if it's a deregulatory case and it goes to the Supreme Court, when Chief Justice Roberts was, he was holding a lot of power in the previous kind of setup of the court, in the previous membership, to play that swing vote and shift, the final outcome to the left and just say the agencies need to do more. If the Supreme Court now is a 6-3 conservative majority, Chief Justice Roberts doesn't have that power. And so you might have, all the other more conservative justices willing to say, yeah, the agency did enough to explain its decision and this regulatory rollback is fine.
So even, just looking at a big picture on climate policy, the Clean Power Plan was, sort of a historic step forward for climate activists, but in terms of regulating carbon emissions. But if you kind of look at what scientists are saying about climate change, it's not a permanent solution to climate change. It's really, if anything, it's a first step. What if in, a Biden presidency or some future Democratic presidency, there's a version of a carbon tax, Green New Deal, carbon legislation? Is it a possibility that a 6-3 Supreme Court could simply block or stymie any efforts to really deal with climate change?
It's definitely a possibility. It depends on how creative a future Democratic administration is in crafting a new regulation and under what power. So if they're crafting a new regulation under the Clean Air Act, they're going to have great lawyers working on it. They're going to find a great way to justify what they're doing. But there are also going to be great lawyers on the other side saying this is beyond what the Clean Air Act is intended for. And that's, again, that argument that we think a more conservative Supreme Court might be pretty receptive to. So, the more ambitious the action, that might mean the more creative you have to get to do it. And the more creative you have to get to do it, the more vulnerable something is in court. The other kind of question mark, though, is whether Congress takes action and changes anything. Congress obviously has tons of power to give federal agencies more authority to do X, Y, and Z to address climate change. So that would really be the thing that would give an agency the most legal cover to take more creative climate action.
So one big decision that this is bringing up for me is something called Massachusetts versus EPA, which, correct me if I'm wrong, Ellen, in which the court decided that climate changing emissions, that carbon emissions qualified under the Clean Air Act as something that the EPA had to deal with. Is it possible that we could see the Supreme Court essentially go back on that decision?
Yeah, and so Massachusetts v. EPA said if EPA determines that carbon dioxide or other greenhouse gases are a pollutant, then it's required to take action under the Clean Air Act. And we could see that revisited. For example, the Trump administration right now, EPA, under the Obama administration, had the Clean Power Plan to cut emissions from the power sector. The Trump administration replaced the Clean Power Plan with the Affordable Clean Energy Rule, arguing in part that, they were bound under the Clean Air Act to only address a very narrow set of emissions issues from power plants and not to look at the whole power sector. So if that case ends up going to the Supreme Court, that could give the Supreme Court a foothold to look at this climate issue more broadly. And there are other cases that could push that question up to the Supreme Court. And first of all, the Supreme Court would have to decide it wanted to hear the case. It doesn't always, obviously grant every case that it gets a petition on. In fact, it denies most of them. But if it took an interest in that issue and you had 5 justices on the court who are willing to revisit that, then you could see Massachusetts v. EPA being struck down or being narrowed in some way. And that, again, would turn the spotlight back on Congress in terms of climate action, because then it would be up to Congress to draft some new legislation and make sure that some agency had the authority to do this.
So we don't know who the nominee will be going forward. The name of Amy Coney Barrett, who's an appeals court judge, a conservative judge, has been, mentioned a lot. Whoever the nominee will be, how will you personally, as a legal reporter, how will you interrogate their record? What will you look for to sort of see what kind of justice they would be?
So the first thing that I look at when I'm looking at any judicial nominee is obviously their environmental record, if they have one. The names that are being tossed around right now, they don't have a big record in environmental issues. So the next thing you look at is administrative law. That's all the regulatory issues that we talked about earlier. And so we see if they have a big record on regulatory issues? Do they tend to be skeptical of agency power? Do they tend to want to defer to an agency's interpretation of the law? Or, do they think that agencies don't deserve deference on their interpretations of law? That's a big question to look at. I also look at what their views are on precedent. Lower court judges aren't going around overturning precedent because they don't have power to do that. So you kind of look at their scholarly writings and stuff to try to get a sense of how they feel about precedent and whether, if they were appointed to the Supreme Court, if they would have a lot of qualms about overturning precedent. Chief Justice Roberts is very uncomfortable with overturning precedent, and he likes change to happen very, very slowly. But not every conservative judge feels that way. So we'll look at the new nominees to see if they have writings or any opinions that suggest how they feel in that regard.
So are there cases that you will be looking at or that you're particularly interested in coming up where this majority could change the outcome of the opinion?
In the immediate future, no, but, looking ahead a little further, yes. So the immediate environmental cases on the Supreme Court's docket, they're not really huge ones. They're not likely to fall on party lines, so we're not expecting big changes there. They have to do with water rights in Texas and New Mexico and some FOIA stuff and just stuff that's not big, high-profile, divisive issues. Longer term, yes. A lot of the things we already talked about. If President Trump stays in office for another term, then we would be looking at these different regulatory rollbacks and whether they end up at the Supreme Court. So those are, like the power plant regulations, the water jurisdiction rule, things like that. If a Democrat takes office, then we'll be looking at whatever climate action they take, whatever other environmental actions they take, and whether those end up at the Supreme Court. And then there's also, just right now, there are a number of petitions that are pending before the court that are sort of interesting. There's one that has to do with a national monument, a marine monument, so a monument, an area of protected acreage that's out in the Atlantic Ocean. And there's a challenge to whether the previous administration had authority to create this protected area, which is interesting in itself, but is especially interesting because the legal issues there are similar to what's going on with Bears Ears, which is a national monument battle that probably more folks have heard about.
That's the monument in Utah.
Exactly. Yeah. So that's the national monument in Utah that's been getting tons of attention over the years. The Obama administration created it. The Trump administration shrunk it. And so depending on, if the high court is looking at those kind of legal issues in this separate marine monument case, that'll just be interesting to see how that could affect the Bears Ears litigation.
Well, Ellen, thanks so much for talking with me about this.
You're welcome. Thanks for having me on.
Ellen Gilmer is a senior legal reporter for Bloomberg Law. Thanks for listening to Trump on Earth. If you like our show, please consider supporting us through Patreon. Just go to patreon.com/TrumpOnEarth. That's Patreon. You can find us online at TrumpOnEarth.org and anywhere you get your podcasts. Write us a review and tell your friends. This podcast is supported by the Robert F. Schuman Foundation. Our producer and digital editor is Andy Cubis. Kathy Nauer is the executive producer. I'm Reed Frazier. We'll see you next time.